If you've ever followed, a high net worth divorce case in the news, or honestly, if you've been through a separation yourself, the actual signing of the papers is.
Mm.
It's usually just the start of the story.
It really is.
The real financial and emotional work is all drawn out in that
Yeah.
fight over who gets what.
It's the highest stakes financial negotiation most people will ever go through. And for anyone navigating it in the UK, the system can feel, well, like a labyrinth of old rules and, constantly shifting judicial interpretations.
Right.
It's not just about splitting assets down the middle. It's a very detailed, very discretionary process designed to achieve one specific thing: fairness.
And that's our mission today. We're taking a deep dive into the complex sources covering UK financial remedies on divorce. We want to give you a kind of shortcut to understanding the legal framework that dictates how everything gets divided: property, pensions, cash maintenance, all of it. We're going to be dissecting the core statute, the Matrimonial Causes Act 1973, and then the pivotal case law that has really completely rewritten its meaning for the modern age.
And the overarching goal, the thing that anchors every single court decision, is multi-layered. It's about achieving a just outcome, sure, but also ensuring the welfare and financial needs of any children are met. And ultimately making sure both people can transition to financial independence as quickly as possible.
And before we get into all the heavy case law, just a quick reality check for you. While we're going to talk a lot about what happens in court, the system overwhelmingly encourages people to agree on their own settlement.
Right, through what's called a consent order.
Exactly. This avoids the cost, the anxiety of letting a judge decide. But when they do have to decide, they follow a very clear structure. Okay, let's unpack this, starting with the foundation.
The starting place for any judge every single time is Section 25 of that 1973 Act.
The 73 Act.
Yeah. Think of it as the judge's legal checklist. The court must consider factors like income, the financial needs of each party, the standard of living they have,
That's it.
age, duration of the marriage, any disabilities, and always prioritizing the welfare of any children involved.
That checklist sounds pretty comprehensive, but a checklist from 1973. I mean, it can't possibly capture the reality of modern relationships, especially the financial side. Did the courts just start, applying these old rules to modern divorces?
No, they couldn't. And that is exactly why we talk about a seismic shift in the law. The original law, honestly, often felt quite discriminatory, especially towards homemakers. That all changed with the landmark House of Lords case, White v. White, back in 2000.
Oh, okay.
This was a huge, big money farming family case, but the principle from it became the law for everyone.
So what did White v. White actually establish? What was the principle that fixed the old law?
It established the yardstick of equality. It made a 50-50 split the starting point for figuring out a fair outcome. And critically, the court said there should be no discrimination between the husband and wife based on the roles they took in the marriage.
This is the non-discrimination rule, and it's arguably the most powerful concept in UK financial remedies.
It really is.
It legally says that the often unpaid work of a homemaker or a primary child care provider, and it doesn't matter which spouse that is regarded as equally valid and valuable as the contributions of the main financial breadwinner. That's huge.
It is. It validated millions of careers that weren't paid in cash.
So equality is the gold standard.
Exactly. A judge has to check any proposed settlement against that 50-50 yardstick, and they can only deviate if there's a good reason to do so.
Yeah.
It just pushes the focus onto the marriage being a true economic partnership.
So we establish equality as the base, but I'm guessing the courts realized pretty quickly that marriage is more nuanced than just, splitting the pile in half.
They did. And that brings us to the next massive fine-tuning. In 2006, you had two companion cases, Miller v. Miller and McFarlane v. McFarlane.
Right.
And they introduced the three foundational principles that now guide all financial remedies, taking the whole analysis way beyond simple equality.
Okay, let's talk about those three. They sound like the holy trinity of financial remedy law.
They really are. First, and arguably most important in most cases, is needs provision. Before you even think about splitting assets equally, they have to be divided to meet the housing and financial needs of both parties, using that Section 25 checklist we just mentioned.
Needs first. That seems very pragmatic.
It is. The reality is that for most divorcing couples, the resources available are, well, they're barely enough to provide for two separate homes and two financially stable lives.
Sure.
Once those needs are met, especially the needs of the children, there often aren't enough assets left over for the other principles to even come into play.
Okay, but what if there are assets left over, or it was a very long marriage? That leads us to the second principle.
The second is compensation. This is about paying back a spouse for the career they basically put on a shelf for the benefit of the family.
Ah,
It addresses the severe financial disadvantage or lost earning potential that one spouse suffered because of choices made during the marriage.
That feels like the court acknowledging the cost of specialization. If one person steps back from a potentially high-earning career to raise the kids, the compensation principle tries to offset that huge sacrifice.
Precisely. It's an incredibly important principle for justice, though, I should say. It's really only awarded in the highest earning capacity cases where that loss is clearly quantifiable.
And the third concept.
That is sharing. This comes directly from the concept in White, the idea of a commitment to sharing lives.
Well,
If the marriage created wealth, both parties are entitled to an equal share of the assets created by that partnership.
right, the goal being to give both an equal starting position on the road to living independently. Now, to apply that sharing principle, we have to know exactly what's being shared. And this is where we run into that crucial distinction between matrimonial property and non-matrimonial property.
It's a key legal differentiator. It often decides whether you walk away with 50% or, significantly less.
So matrimonial property is the pile of assets built up during the marriage. This includes the family home, no matter how it was bought, and it's the main focus of the sharing principle. Non-matrimonial property, on the other hand, is what you brought into the marriage or what you got from an inheritance or a personal gift during the marriage. It's wealth the partnership didn't create.
And the sources show that the length of the marriage is like a time bomb on that non-matrimonial property. In a short marriage, the court usually tries to keep that separate wealth distinct.
But the longer it goes on,
The longer the marriage goes on, the more those two pools of assets blend together, or mingle, as the lawyers say, and that distinction just diminishes, often leading to a much wider sharing.
and this is where it gets really interesting because we can see how the courts apply these principles in some pretty dramatic edge cases.
Hmm.
Let's look at EVL, a case that shows just how hard it is to argue against that sharing principle, even in a short relationship.
This was a fascinating case. The couple had a very short marriage, just 2 years, and no children, although they had been in a serious relationship for a bit longer. The husband was a very high earner, the wife was a lower earner.
And the stakes were massive. The wife asked for 50% of the joint assets, which was about £5.5 million. The husband argued that because the marriage was short and childless, her claim should be strictly limited to meeting her financial needs.
Yeah, his offer was about £600,000. He was saying she shouldn't get a share of the marital wealth at all.
And the court.
The court rejected that argument completely. The judge, addressing the short marriage and lack of kids, made it really clear that those factors only relate to the need for ongoing spousal maintenance, not the fundamental sharing principle. The judge actually said that factoring in the lack of children would be to make windows into people's souls, which the court shouldn't do.
Wait, so even with a marriage of only 2 years, she still walks away with millions? How is that justifiable fairness?
Because the judge determined the partnership actually started earlier, back in 2016, when the relationship became committed. And once you start sharing assets generated during that partnership period, the duration alone doesn't logically distinguish the accumulated wealth. This gave us the judge's memorable phrase, the white leopard principle.
The white leopard.
Yes. He said that departing from an equal division of matrimonial assets earned in a short marriage is as rare as a white leopard,
So almost impossible.
an incredibly high bar. The court ended up dividing the partnership assets equally, and the wife was awarded just over $1.5 million. It's a profound illustration of how robust that sharing principle is once wealth starts to build up.
That clarity really helps you understand where the legal bar is set. Let's pivot to spousal maintenance next, because that's often the most contested area, and it's covered by the guidance in NSV-SS.
This guidance was a crucial check on what had become a bit of a culture of lifetime maintenance awards. The fundamental shift is away from joint lives orders, where you pay indefinitely and firmly towards self-sufficiency.
So no more wife-for-life payments.
Not if it can be avoided. Maintenance should really only be awarded when a spouse has demonstrable future needs that are causally connected to choices made during the marriage. And here, the length of the marriage and the presence of children are absolutely pivotal factors.
And if the needs are not connected to the marriage itself, say if one person just struggles to earn,
Then the award is only aimed at alleviating significant hardship. It's not about maintaining the high material standard of living they had during the marriage forever. The court has to constantly consider putting a time limit on payments, ensuring a transition to independence as soon as it is just, and reasonable. It even accepts that a degree of not undue hardship during that transition is acceptable. It's really pushing both parties towards financial autonomy.
It sounds like the whole system is determined to untangle the couple completely. Now let's talk about agreements made before the couple even said I do, prenuptial agreements. For decades, the UK courts basically just ignored these documents.
They did.
That changed dramatically with Radmacher v. Granatino in 2010.
This is the definitive case. It involved a wealthy German heiress and a French investment banker. They had a prenup drafted in Germany saying neither would benefit from the other's property if they divorced.
But the husband?
Well, the husband initially won a staggering £5.5 million award in the lower court, which completely disregarded the prenup.
But the wife relied on the prenup, and she challenged that decision. What was the outcome?
The Supreme Court upheld the agreement. They found that because it was freely entered into by both of them with full knowledge of the finances, it should be respected. The husband's award was slashed dramatically to an £800,000 lump sum, plus some maintenance and the use of a property while he was still parenting their children.
That is a stunning legal reversal based entirely on a piece of paper signed before the marriage. So what does this mean for the average couple thinking about a prenup?
The legal takeaway is clear. Prenups will now be given decisive weight in England and Wales, unless upholding them would be unfair to one of the parties.
Unfair meaning?
Specifically, if it fails to meet their reasonable needs or the needs of any children. But it formalized the idea that if you sign an agreement freely, you are highly, highly likely to be held to it.
Okay, moving on from the content of these orders, let's turn to procedural fairness, because the whole system breaks down if people can't trust the starting information. What is the legal consequence for trying to hide assets?
That's treated as a major legal fraud. The cases of Gohill v. Gohill and Sharlin v. Sharlin are sort of the nuclear options for the court in these situations. The requirement is one of full and frank disclosure of all assets.
And if you deliberately and fraudulently fail to disclose?
The Supreme Court ruled that a failure like that allows the party who wasn't at fault to petition the court to set aside the entire original financial settlement.
The whole
thing. They get to reopen the case and seek a potentially much larger award based on the newly discovered wealth. Transparency is non-negotiable, and concealment is a fast track to disaster.
That's a huge safeguard. And beyond disclosure, the entire process is governed by procedural rules known as the overriding objective.
Correct. The procedural rules are all designed to ensure cases are dealt with justly. This includes making sure the parties are on an equal footing, saving costs where you can, and most importantly, dealing with the case in ways which are proportionate.
Proportionality is key, right? You don't want a couple spending £1 million in legal fees to argue over $100,000.
Exactly. The process has to be proportionate to the money involved, the importance of the case, and how complex it is. It's about getting a fair outcome without, incurring unreasonable expense or delay.
As we look to the future, there seems to be this clear and ongoing tension in the UK system between the immense judicial discretion we've talked about, all that case law, and the push for greater legal certainty. That current law, the 1973 Act, it just doesn't reflect all the judicial developments we've just covered.
That lack of cohesion is the biggest recognized problem. The Law Commission, which recently reviewed this area, found that the current law lacks certainty and accessibility. If you're a member of the public or even a junior lawyer, you cannot read the statute alone and predict the outcome of your case.
So it's all in the case law.
It relies far too heavily on wide-ranging judicial discretion to achieve fairness for each individual.
So reform is necessary, but how do you fix a system that relies on judges being flexible? What are the models being considered to get more certainty?
The Law Commission outlined a spectrum of 4 potential models for reform. At the sort of moderate end, you have simply codifying the existing law.
Okay.
This just means taking the decisions from White, Miller, and Radmacher and writing them into the statute. It makes the law transparent, but it still preserves that judicial discretion to achieve fairness in unique cases.
So that's basically just cleaning up the rule book. What's the next step towards more certainty?
The next step is codifying the law plus statutory reform on discrete issues. This means they'd codify the case law and also create fixed rules for specific areas, like prenuptial agreements, maybe giving them automatic legal force unless they lead to unmet needs.
And the final, most radical option, the one that guarantees the most certainty.
That is creating a matrimonial property regime. This is where the law predefines exactly which assets are shared and how they're split. offering the greatest certainty and the least judicial discretion.
So a couple gets married, and they automatically know, almost down to the penny, how their assets will be divided if they divorce, regardless of a judge's view on their needs. That's a fundamentally different type of family law.
It is. It swaps the flexibility that allows a judge to tailor an outcome for exceptional circumstances for the predictability that allows ordinary people to settle their cases quickly and cheaply, avoiding court altogether.
It's a huge policy debate.
A huge debate. And they're also looking at smaller reforms, like formalizing the add-back principle, making it easier for the court to recover assets that one party deliberately wasted to reduce the available pool.
So, to summarize what we've unpacked for you today, the UK system is built on an old statute, but it's entirely shaped by this revolutionary case law. Equality is the starting point for sharing matrimonial assets, but it's immediately checked against the needs of both parties, especially where children are involved.
And those three core concepts, needs, compensation, and sharing, they define the outcome. And they rely on full and frank disclosure and a procedural system that enforces proportionate legal conduct.
Right.
And courts are consistently focused on allowing parties to achieve financial independence as soon as it's justly and reasonably possible.
The ultimate shape of your financial order depends heavily on specific parameters. How long you were married, how much of your wealth is matrimonial versus non-matrimonial,
Yeah.
and the value the court places on the total contributions made by both the homemaker and the breadwinner.
And that leads us to our final thought for you to chew on. The current system relies heavily on judicial discretion to ensure fairness in unique family circumstances, and it accepts a lack of certainty as the price for that. But the Law Commission wants to introduce more legal certainty, possibly through a fixed matrimonial property regime. So, if the law moves in that direction, would the gain and predictability be worth the potential loss of tailored judicial fairness for complex or exceptional individual cases? What value do you place on certainty versus flexibility in this really sensitive area of law?